This meeting to study Rule 1.8. Let me get my little being recorded and live streamed. So first, I want to thank you all for joining us and taking this time out in the middle of your day for us to convene and talk about this much needed discussion, further this discussion. First, I want to read the Ethics Act statement. Members of this committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict. If you have any, let us know or refrain from the discussion. All right. So I figure starting right out the gate, Nicole, if you want to get us kind of up to speed. Well, did everybody get the emails that included the latest revision?
Yeah, so I sent an email the other day with our proposed rule amendment. And then this morning I sent you one document that includes a list of the other states that have a humanitarian exception in their Rule 1.8.
Exactly. All right. So did everybody get those and get a chance to look at those? I think they were super helpful. And it made me feel, I will say out the gate, it made me feel really, really good with the discussions we've had and the efforts we put in with the language and the wordsmithing that we did with ours. Is there anything else, Nicole, that you wanted? Everybody did get the latest version too with those revisions in it. Was there anything that you wanted to say in regards to those two things right out the gate, Nicole, before I open it up?
Not really. I mean, Brian and I worked on this, and we think we have added the language that you wanted us to add, which was just going to add lawyers who are appointed to represent indigent clients. So that's what we did. So there's not a whole lot of additional language. There are some comments that we added some language to comment number 11.
Okay.
And again, just to include indigent court-appointed lawyers who represent indigent clients.
So can I ask I had a question, immediate question when I saw these revisions or these edits. I can't remember exactly what our discussion was, but I thought our discussion was about including these two different sets of clients, which would be indigent clients and then court-appointed clients. And I think you all have it in here as indigent court-appointed, as if it's one group. And I just wanted to solicit others to give feedback as to whether you remembered it the same way, because I'm saying court-appointed in and of itself means that they're indigent. So I think that's redundant to have indigent in front of the court-appointed.
Okay.
But I thought our discussion about indigent was a lawyer representing an indigent client pro bono, and then a lawyer representing an indigent client or a court-appointed client.
Yeah, and so I'll offer a little bit of maybe it's some question that we had too when we were looking at this stuff, kind of like what exactly were we talking about? Because there was, I think there was the hesitation to open this up to any representation, like personal injury. And I know that's probably a conversation that maybe needs to take place. I don't know whether it's here or it's a later point. That can be a discussion point. But one of the things with that hesitation about opening it up, if you had it just that an indigent client period would qualify for or be, I guess, eligible for financial assistance, then that does encompass personal injury. You could have an indigent client who is a personal injury client, and or any other type of client. And I guess that was the thing that we weren't sure. We wanted to get the subcommittee's feedback on if we don't want to open it up, so to speak. We only want to restrict it to indigent clients, but is it certain types of indigent representation, as opposed to like, are we okay with if it's an indigent client but it's a personal injury case, or indigent client and it's a family law case? But they technically qualify under whatever definition we use for indigent client. Then but they're privately retained attorneys. They're attorneys who are being paid and not even doing this representation pro bono. They're getting paid for their representation. They can still do that financial assistance. That was the thing that we weren't sure if you all wanted to potentially open that door with that terminology. So that was one of the questions. And the redundancy of the indigent court-appointed client was one of the questions that we had because we had a similar sort of reaction. We're like, is that kind of redundant? Like you said, isn't everybody indigent if they're court-appointed? And I guess that was a question that we wanted to ask, based upon everyone's experience here. Does anybody ever get court-appointed that's not indigent? Because we wouldn't necessarily want to exclude that if there's any scenario in court-appointed cases, including child welfare cases, criminal representation, et cetera, and or workers' comp, or something like that. We weren't really sure. I wanted to get everybody's thoughts on that before we put
the rules, the IDS rules indicate that the person is supposed to be indigent. And I will be quite frank that we as judges, and I have learned since I've become a judge, that we don't get a criteria given to us to determine what that really means. So each judge individually has to make that determination based on the information that is provided on the financial affidavit. So that's the answer to that. But the rules do say that the person is supposed to be indigent in order to receive counsel. And that even includes those child welfare cases.
Okay, great.
So that's why I think that having indigent in front of court appointed is redundant. But I would like for us to have more discussion on that other piece, which is, should we include in this list just indigent client and not specifically say indigent client pro bono and court appointed, but have another carved out one. I see, Stuart, you have your hand raised.
So yeah, I don't have a strong feeling on indigent court appointed. I'm fine with taking indigent out based on what you've said. As far as the other issue, I'm sympathetic to my brothers and sisters over at Legal Aid who said that this needs to go through. And I think we could put it through comfortably as written. However, if we just do a group for indigent clients, I am not comfortable putting this through right now. And I would think it would need more study. And so I think maybe a hybrid, I'm curious, how many times do you want to go to the well on this, on a rule amendment on this issue? But so I looked at Brian and Nicole for advice on that. But I think maybe a hybrid where we agree to propose this and then maybe have a subcommittee to study the separate issue so that this is not held up in that subcommittee study.
Got you. Thank you for that, Stuart. Ashley?
Couldn't find my little Zoom hand.
It's okay. I'm perusing through. I can see.
Thank you. I think the first thing I just realized is I think I might need to disclose that I could have a conflict of interest because I am the executive director of Legal Aid of North Carolina. Because I share Stuart's concerns. Now, I'm trying to think if I would share the concerns if I wasn't at Legal Aid. Because I was involved in sort of legal services work before I was here. I do think that it will get bogged down significantly if it is broader. And that there is a desire to get it passed because there are a lot of local governments who would like to provide rental assistance for low-income clients who are sitting on the sidelines sort of waiting. So just to give this committee some background on that, we've had several people approach us at Legal Aid wanting to give us, significant dollars to help people with rental assistance because it is just well known that it is a way to keep people housed. So, when you've got a client in a landlord-tenant case in particular that's $3,000 behind on rent, they are not going to be able to come up with that money, but rental assistance will often help them, pay the money. Maybe they were out of work and now they're working again. So they're going to be able to maintain their housing if they can get the rental assistance paid. And I just want y'all to know that local governments, they want to do it. So I do think that in that case, that the longer the state bar takes on this, it will impact people's housing. It could impact people's housing. So just want to make everyone aware of that and also disclose that I think I might have a conflict as it relates to like the speed at which I think this should move through the. And I don't really know what I do if Warren's shaking his head. Do I have a conflict, Warren?
I don't think so. No more than any attorney that
Right.
any attorney that represents clients that might benefit from this. I mean, you're not asking for the gift.
Right.
Right.
No,
Well,
I-
that's definitely true. Okay, so-
Let me add my agreement there, Ashley. I think
Okay.
that's the exact thing that I was thinking about with Warren. If that's a conflict, then every attorney that's ever been on a committee is conflicted out. But the conflict comes up is if you in your position, you're effectively like trying to push through something for your client specifically. You are acting as a counselor. Yes, your livelihood, or not your livelihood, excuse me, what you do for for your job could be impacted by this rule, just like every other rule can impact your ability to practice and every lawyer's ability to practice. So until you reach that internal spot where you feel like I am officially trying to work for legal aid and push something through and under the veil of a counselor position, which you're not, because that's just not you. You're not at the spot of a conflict.
Okay, thank you guys.
Well,
Thank
we
you
do-
for your help on that.
But we do thank you, Ash, for pointing that out, because that shows
so-
everyone in Zoom land how cautious we really are.
Yes.
Yeah, and so I do have a follow-up question then also, which is about the word modest. And I know this has come up before, but so if we could just use the example that I just used of, a client, a rental assistance fund that's available that would not be advertised, not be an inducement to representation. A client is accepted at legal aid. Legal aid determines that the client could be a beneficiary of rental assistance, then makes it known to the client. Is a $3,000 rental assistance modest? Now, it looks to me like based on the comments that is sort of like a subjective test, which says, is it a circumstance in which it creates a conflict of interest or invites abuse? I think the answer to that is no, but I don't know if that amount is modest. And I bet Jack has ideas about that too.
Yeah.
No,
I'd love to
I
hear
think I'm sorry, Warren, were you going to say something?
No, I'll wait for you, Jack.
No, right. I think that's a great question, because under other circumstances, a $3,000 gift might be outside of the range of what we would define as modest. Mike, I think he's dropped off for a second here, but he was giving some great scenarios last time around about real modest, right? Like a ham and cheese sandwich and a Diet Coke and, that kind of thing. But last time that we talked, I think the range of modesty, the way we were defining it, definitely exceeded the ham sandwich. But $3,000 is definitely different. And going to Stuart's point about expanding it to any indigent client, right? And Stuart, if I understood what you were saying correctly, we would now be getting into the zone of potentially really to the classic champerty and maintenance that this whole thing was created to avoid in the first place. Whereas that's almost certainly not going to happen in Mike's scenarios from last time, or in a legal aid scenario for most situations. But the potential for actual real champerty and maintenance could arise with and this is, as Stuart said, nothing against what did you say? Nothing against our brothers and sisters on the plaintiff bar. But you're right. That is the danger. So let's take Ashley's hypothetical and then plug it into what Stuart was saying. You got you've got a personal injury attorney handing out $3,000, $4,000, $5,000 in cash. We are in champerty and maintenance now, right? I mean, but Ashley, the only thing is that the way the money is doled out under the scenario you're giving is within very narrowly defined parameters for a specific purpose. It's not like you're giving them that money, to go, to Vegas for a blowout weekend or anything like that. Although I don't know if 3,000 is enough for a blowout weekend anymore in Vegas, but yeah, I mean, so maybe the way in which it was given fits under a modesty definition that $5,000 in cash from Joe, the ambulance chaser, again, no offense intended, would be very different. That's a great question.
So let me ask this. Are we at a place where we can have a discussion and see if we have an agreement in not moving forward with the insertion of just indigent client. That way we can just take that out of this discussion completely.
Like Warren has a point.
Yes,
to make.
Warren.
I think I was the one that was probably pushing this more than others, and I'm going to withdraw any pushing there.
Okay.
And basically say, I think the whole idea of expanding it just to the indigent client versus the court-appointed indigent client is a different terrain. Having talked to Stuart's colleagues and others, I think there's great concern that this idea is opening a can of worms, and that we should be very, very careful. Not all lawyers are, I don't want to say trustworthy, but some lawyers are a little more subtle in how they might market such things than others, and they are concerned about that. And I agree that we might not go there, especially because we're not even asked that. We're really just asked, right? This is a question from there doesn't seem to be some big push to do that at all.
Right.
This is a question because people have called the office when they truly have an indigent client in a very difficult situation, pro bono situation, and want the ability to do something to help them. Then I think we should go ahead and move forward with this and that, only in that respect, and maybe see what the comments are. And if there is some push to look at that question on whether to expand it farther, then we can decide whether to do another subcommittee and make a change there. But I guess old dogs can learn new tricks. I've changed my opinion about pushing.
All right. Thank you, Warren. So I did remember correctly that you opened up that can of worms and now you're closing it.
I'm closing my can.
All right. We appreciate that. Does anybody else have any comments on that? Or am I taking it that per our discussions thus far, we're in agreement with not including that in the list, just regular indigent client? Okay. All right. So I would like to, so that should help us kind of move our discussion along to what we really need to talk about, which Ms. Ashley, I appreciate that, because I think that modest is where we kind of ended the last time. We had a lot of discussion the last time about what that really is and whether we should include like a certain amount. If I'm remembering correctly, somebody please correct me if I'm not remembering correctly, but I thought we had a lot of discussion about should we insert a certain amount that folks could give and things of that nature. And that kind of takes us back to the materials that Nicole sent, which I believe were very, very helpful. And I noticed in those that there were different, scenarios. I mean, different ways, the approaches to this. And a lot of the states did not, they allowed for living expenses, but included repayment, which we don't even get into on ours. And I'm not suggesting we do. And that I know one in particular I put in my notes that Mississippi had like a $1,500 cap, which might be appropriate for Mississippi, but $1,500 for a rental assistant in Raleigh or Durham would not necessarily be sufficient. So that's something to think about. And then somewhere like Utah was very short to the points, very short, sweet, kind of in there, out. So let's talk more about that word modest and, kind of where we should go there. So I know, Ashley, thank you. Like I said, we got you starting that discussion off. Does anybody else have any comments or thoughts on that word modest? I do think we do need to flesh that out some more, because I think that is where we're going to get some more questions, because quite frankly, even if we were to put a cap, somebody getting rental assistance could eat up that entire cap all in one swoon. Yes, sir.
I've always thought modest is in the eye of the beholder. What's modest? I mean, any gift to some of these indigent clients is going to be more than modest. I mean, that's given they're coming from very poor backgrounds. So $100 to them means a whole lot. Whereas to us, it's, not, it's a date night. So I kind of, I like the idea of discussing it, but maybe not at this juncture, trying to put a dollar limit on it because, because in the comments, we may get some good comments that help us get, because I just have a hard time imagining the whole, I would have thought before Ashley mentioned this whole rental fund that $3,000, heck yeah, that's way more than modest. But now I'm like, oh, is it?
Right.
and it's hard, I would have said it shouldn't be over $500 or something like that. Well, that doesn't really meet the purpose of what we're trying to meet here. And I'd like to see what sort of people want to do if they are willing to talk about it, because I would not want to impede the intentions of this program at Legal Aid.
All right, thank you, Warren. Stuart, and I do see your question, Ashley, in the chat.
Sorry. So I was just looking at the language that Minnesota and North Dakota used. And I like this language for this circumstance. My only concern is that if ultimately there is study about expanding this to just the broader group of indigent clients, that might be language that I wouldn't like in that circumstance. But the language that I'm talking about it's subsection 3 in both of them. It looks like the same language. And it's let's talk about guaranteeing a loan, but ignore that part. And it says reasonably needed to enable the client to withstand delay in litigation that would otherwise put substantial pressure on the client to settle a case because of financial hardship rather than the merits. Then along those lines. But that could be something we could consider. But I mean, I'd also like to discuss Ashley's suggestion of just removing modest. But again, my concern with either of those two scenarios is future implications. I don't have a problem with either of those necessarily here in this circumstance.
Okay, thank you for that. I think that we can, Ash, are you okay with us going to Nicole and then coming back? Because I think that we can probably have some good discussion about coupling that question and Stuart, your suggestion to look at that language, because I think if we look at that language and take that language, we probably could remove the word modest. Nicole.
So my only concern about removing the word modest is the lawyers who have the deeper pockets providing more than what the client really needs. And there's an example that I have, and I won't name the lawyer, but a firm who wanted to give a television. And we have an ethics opinion on that. But so I don't want it to be so broad that the lawyers think that they can provide a television. When, everybody likes to have a television, but, is that really what our humanitarian exception is supposed to be about? I mean, I'd like it to just be more about things that they need to survive rather than things that they need because things that they want rather than what they need.
Do you think that if we were to include the language that speaks to providing for basic living, reasonably needed to enable the client to withstand ... kind of what Stuart was talking about, that could cover those circumstances?
That would make me happier, yes.
Right. And that's why I was thinking that we could probably have that, think about maybe inserting that language. And if we wanted to take out the word modest, that would cover, you know what I mean? What do you all, anybody else have any thoughts?
Well, I can
I like
offer
that language too, Stuart. That was one of the notes that I took too.
I was going to say, I like the language too. The thing that I'm trying to ponder in my head is, does that tie it too much to the actual litigation and I guess take away like the scenario, the very reasonable scenario that Mike was talking about before of, you've got a court appointed case. There's nothing that if Mike puts some money in his client's account so he can get that honey bun or whatever it is, that's not affecting a delay in litigation or put substantial pressure on anything. I feel like do we want to still allow for just kind of for a lawyer to be able to be nice in that regard? And it doesn't have
pack of
anything to do with,
cigarettes, right?
Yes.
yeah, and that's, so I'm wondering, I was trying to jot something down here that it sounds like just from the conversation we're having that, yes, this is going to be a vague thing that I'm about to say, but what constitutes modest is dependent upon the client's circumstances and their needs for basic living expenses. I think we could have as an example some of the language that you see that Stuart cited. This could be in a comment. I think that would be an explanatory comment that basically says it's dependent upon the client's particular circumstances and their needs for basic living expenses. Examples could include, some amount that would assist the client in withstanding a delay in litigation or settling a case to, because of financial hardship rather than the merits. I feel like, you could, I don't know if you want to go so far as to give examples, that like, paying a utility bill versus assisting a client to avoid eviction without saying, paying rent or whatever, but like assisting a client to avoid eviction, like you said, Warren, $3,000 to the client who's not looking at eviction, but they're looking at perhaps their lights being turned off, their heat being turned off. You don't need 3,000, and that would be probably not reasonable under the circumstances. But then the person who's facing eviction, and you have legal aid with a gift that's been made to facilitate keeping someone in their house, that would be reasonable under those circumstances. So it's kind of the thing that we were talking about in the double billing subcommittee on Tuesday, that allowing lawyers to make or to exercise their professional judgment and relying upon that. I know that opens a door for abuse, but I think we've already got a rather narrow exception that addresses that potential for abuse. So, perhaps this wiggle room is what's appropriate and professional. What do you all think?
I agree with that. And the short answer to your first question of, do we want to be able to still allow for people to just give gifts? Yes. And I think that you're on track with the way we need to word it to cover all of that, because either way, we're going to have to give some credence to the lawyer themselves to determine what that is, whether it's using the word modest and them trying to make a determination, or over here on this side, we use this language and they have to determine what reasonably constitutes, what this particular client needs based on their particular circumstances, unless we go back to law school days and use like the reasonable person standard, objective versus subjective and all of that. And I don't think we want to go there. So, yes, Mike.
Calling on me. I'm sorry. I don't know how to use those buttons and stuff in my set.
You are just fine.
I don't either.
I did it. I tried it earlier and I lost the whole picture. I like the idea of modest because it's determined or defined by what it's kind of gift it is. If it's food, modest is one thing. If it's rent, modest is another. What might be modest in Raleigh for rent might not be modest in Charlotte for rent. So, yeah, I don't think we need to fine tune this that much. Again, I'd leave some of the discretion to the lawyers, subject to abuse. But I mean, it's their money. It's our money.
Yeah. And
so I think modest is fine.
Yeah. And by making it pro bono clients, there's no financial incentive for the lawyer other than just making a gift, right?
As long as that's clear. I mean, I believe I said from the
Right.
get-go, as long as there's no quid pro quo of any kind, I think my modest is fine. Thank you.
So Ashley, I want to swing back around to you because you threw the question out there, but I don't know if we really got your position on that question.
So I think I was just tossing it out. I think
Okay.
based on what I've heard, I'm comfortable keeping it. You know what I was just thinking? I was thinking, because I'm the sort of person that when we structure a program or something like that, I go to the state bar and ask, like, does this look like something that is okay under the rules? So one thing we legal aid could do if it decided to do rental assistance is if it passed in this way, I mean, we could seek an advisory. I should know what these things are called. Sorry. And we could get clarity there on what's doable. And because it feels to me like the rental assistance piece is really different from some of the other things. I mean, the rental assistance piece to me feels like the piece where it's going to be a more substantial sum.
Mhm.
I mean, I know you could, put somebody in a hotel overnight so they could attend their hearing or something like that, and that could exceed $1,000. But I just think that's going to be more rare. So if this committee, my biggest concern would be a group of folks on a committee, a grievance committee, who wasn't partial to these discussions and thinks of Modest, like probably most of us did when we first heard the word. And then, there's a problem. That would be my only concern. But I think, I just think maybe we could seek an opinion if this rule was implemented around rental assistance that could probably help give some clarity on that.
Be careful what you ask for.
Or not. Or not. I think it's fine. I don't know. Jack, what do you think?
I think in a way, this is such a different thing than everything else. When you read the rule itself, it clearly is not contemplating a law firm acting as a clearinghouse or distribution center. I know why they come to legal aid. We have contacts in all 100 counties, and we have contacts with the folks who need it. And so it is a great distribution point, but whole-scale distribution of huge sums of money in almost a government program type of way seems like almost a category difference than everything else that's being contemplated. If you take that scenario out, I think we're done, or at least before we start considering other groups of quote unquote indigents. But so I think that, is there a potential here that there's a carve out for something as dramatically different as a quasi-private, quasi-governmental entity like legal aid acting as a distribution source for other government funds that is just not something that 1.8 even is supposed to be interacting with? And I say that in the sense, Ashley, can we carve that out or something like that so that we don't even have to worry about some of the potential conflict in the language?
Warren?
Yes, my question about the whole thing is, what if this was a fund, a separate entity from legal aid itself, that was people gave money to in trust, and that trust decided that they were only going to help legal aid clients? That's not a gift from legal aid. That's
Right.
And I
that's a
asked,
separate trust that, I mean, that's like, couldn't you refer, lawyers refer clients to other sources of income or loans or whatever all the time.
Well, that's right. I mean, the first sentence, a lawyer shall not, or a lawyer shall. This isn't the lawyer's money. We're just helping the system because we're probably, for this specific thing, in a really good place to know how and where it could operate. But it is a different source. It's not the lawyer's money type of thing.
Yeah.
Yeah, and I'll just say, I think that was one of the unique things about the proposal for rental assistance in a variety of contexts, that gifts are being made to those that are the representatives. They're the lawyers. And the lawyers are supposed to use this money for rental assistance, but it's essentially in the lawyer's account. It's in their discretion to dole it out as they see fit. which then once it becomes in their possession and under their control, it's hard to distinguish that from the other situation where the lawyer has in their possession and under their control a different set of funds, or maybe a set of funds that was sourced from somewhere else, and
Right.
that one is a gift and one is not. It's,
Mhm.
I think that's where it became difficult under our current rules to actually to try to create that carve out. But I think still, like, this whole thing, I'm wondering, I feel like we have two options. One is just to go with the language modest and just leave it at that. And yes, there's going to be questions of interpretation. But I have to say, and I know this is not necessarily like the comforting thing that you just want to just rest on, but I can't imagine people filing grievances on this.
Me either.
So, but like,
I
of
thought
course,
this at the beginning.
right, but of course, being the former office of council person, I'm like, but I've seen some pretty crazy stuff. I remember having a grievance against somebody because the guy didn't return his neighbor's lawnmower in a timely fashion, and he thought that was stealing. So that person is now disbarred, by the way. No, I'm kidding. That's not true. I think that's the sort of thing with like the modest gift. We could just leave it as is, allow for interpretation, and really, like, when it comes to, frankly, enforcement of this rule, that wasn't a modest gift. Well, you get into an argument about what is and isn't modest under those circumstances, and I don't think it really goes anywhere. The other option would be to try to provide some guidance on the thought process here in the comment, with some language that basically talks about whether something is modest is dependent upon a variety of factors, including the client's circumstances, the client's needs for basic living expenses, the type or purpose of the gift, and then maybe we can incorporate and whether the assistance is needed to enable the client to withstand that delay in litigation or otherwise would put somebody in that position. Of course, I'm not just like, spitting this off the top of my head, because I actually wrote it down, and I'm going to share my screen to see if you guys like this.
I think that second option would be good.
So,
And I think while you're pulling it up, I think that the fact that we are not entertaining this loan provision that we saw in some of the other states is what keeps us pretty much, I'm not gonna say in the clear, in a good place with not receiving grievances when it comes to modest gifts. Because we don't have a situation with the loan where somebody's like, I was expecting for them to pay it back to me, and now they're not trying to pay it back. You get what I'm saying?
Totally. Yep. I agree. Can you all see this on your screen, the language I drafted? I'm sure it can be improved. I just drafted it while we're talking. So if you have any other suggestions, or we want to, go back, and Nicole and I can work on this. Nicole, I don't know if you have any other thoughts too. That's we just kind of probably need to just talk this thing out, but this is the embodiment of the idea that I was trying to spit out here.
All right, one question that I have is, do we want to look at where you have and whether the assistance is needed, or whether?
That was going to be my only comment. Yeah.
Mhm.
Just to make sure it's read that I think that's what we intend.
Yep.
That's right. Yes, it is. Good call.
I think that's
Otherwise, I'm
really
fine.
good.
Me too. Anybody else have comments?
Just only as an aside to what Brian said before about who's going to make a grievance here. Going back to our earlier discussion of expanding it beyond the pro bono and court-appointed indigent clients, where somebody goes to Stewart and says, Warren Savage said he'd give me a car. Will you, but what can you do for me? I can see where that grievance is going to come from against me. It's going to be from Stewart. Other lawyers reporting that they're getting outbid.
Yeah, Brian and I talked about that it really won't be clients who complain about this rule. It'll be other lawyers.
Other lawyers. It's going to be like advertising rules.
Yep.
Absolutely. All right, any other comments? So it's not hearing any opposition. It sounds like we're in agreement with this addition that you just made, Brian.
Okay.
All right.
If I just wrote something on the fly really quick and it's good, then I'm gonna quit after this and call it a day. Like I want to end on a high note.
Well, I don't know about that. At least get you some cheesecake or something.
Well, so to this point, Dorothy, I want to make sure everybody's on the same page because it sounds like, I don't know, it sounds like we're heading towards a spot of consensus.
Mhm.
So let's kind of show, this was what Nicole sent out earlier today, or excuse me, earlier this week. And this would be the proposed amendment here. And I guess I have to say, we'll format this in a way that is really amending the North Carolina rule. This is kind of our amendments to the model rule, that just so everybody's clear on that. We'll have to do the numbering and all that stuff. But basically that this new sub 3 this is the model rule language with our addition here of a lawyer representing a court-appointed client. I removed the indigent court-appointed client for redundancy purposes. But otherwise, oh, and I did add a comma because I'm a fan of the Oxford comma, but that's just me. But otherwise it remains as is in the model rule. Is there anything that anybody feels like is inappropriate or needs to be changed with regards to, like, this would be our proposal that we're adopting the model rule sub 3 as well as our North Carolina specific addition of a lawyer representing a court-appointed client?
I think we're in agreement.
Okay. And then these would be the comments. Again, we'll have to work on the numbering, however it works within our current set. But this comment here, starting with paragraph E3, provides another exception. And then the other comment that has this new language that we just discussed. But otherwise, the proposal would be to include these comments as drafted as new comments to Rule 1.8.
Yes, with it, of course, making that consistent with the language in the actual the rule, which taking out indigent in front of court appointed.
Yes, thank
But
you.
otherwise, yes.
Thank you. Okay.
I have one question about a word in comment number 12. Are we looking at comment number 12 yet?
Sure.
Which is, and I don't have a strong opinion about this. This was the only thing I noted when I reviewed it before the meeting, which is the second sentence: modest gifts are allowed in specific circumstances where it is unlikely to create. I wonder if I don't know if you need the word specific there. You could say, the modest gifts are allowed in circumstances where it is unlikely to create conflicts of interest or invite abuse. I just think that's a really nice test right there. And I wondered if you left the word specific, if the grievance committee would think, well, what are the specific circumstances that the committee was thinking about? So, I don't have a really strong opinion on that, so I don't want to bring it up.
I tend to agree with you, Ashley.
Yeah, I think it's a good point. I think it's a good point.
Yeah, I don't have any problem taking it out.
I think it does kind of create the question of, so what specific circumstances are those? And are those to be articulated for enforcement purposes? But I don't think that's the intention of this.
All right. Nicole, do you have anything else?
I do not. I have my marching orders, so I guess then, are you all in agreement that this is what will be presented to the ethics committee, or do you think you need another committee? I think it's ready to go to the ethics committee, but
I think so too.
I think so.
And I think isn't this the third meeting?
Second or third.
I was gonna say just second.
Second
Yeah.
meeting.
Okay. I think we creating a record.
Well, going back to expanding this to all practice areas. Let's
No.
kidding.
No, sir. We got our charge and we have achieved our mission.
I hear you.
Stay focused, everybody. All right, so we'll get the revision, the complete revision from you all, and then we'll be ready to present that at the next ethics committee meeting. Of course,
Okay.
I know you'll send it out to everybody because I know we have some other members that weren't able to be present today. And just in case they might have some comments, we can address, we got time to still address those if we need to. Does anybody have anything else before we? All right.
Good job. You're quite a leader, Dorothy.
Well, I appreciate you.
Yeah, Brian, I want to be on all of Dorothy's led committees.
Yeah,
Amen.
just getting stuff done.
Well, I appreciate you all. And so we will convene again if we have to, but we don't think that we will need to, and we will see each other again for this particular question here or discussion at the ethics committee meeting
In April,
in April. Yes.
April.
thank you, everyone.
All right, y'all have a good rest of your day. And as always, Nicole and Brian, thank you so much for all the work that you do for us behind the scenes. And I
Thank
hope
you,
you all
Nicole.
have a good rest of your day.
Our pleasure.
Thanks, you guys.
Have a great day.
Bye.
Great to see you.